Hi, this is Joe Miller, North Carolina Workers' Compensation Attorney with the Work Injury Center at Joe Miller Law. Welcome to our Critical Info CD for injured workers in North Carolina. First of all, I want to congratulate you for having the presence of mind to order my book, The North Carolina Workers' Compensation Guide to Settlements, and order the Case Success Toolkit. It shows that you're an intelligent person and you want to make smart decisions about your life. Because believe me, in particular, those of you who have suffered a very severe injury involving surgery or multiple surgeries, right about now, I have no doubt that your life is turned upside down. Besides the fact that you hurt so badly every day, you probably feel a little like a criminal. You've been made to feel that somehow the fact you got hurt on the job is your fault. Because, you're the one who's in horrific pain and suddenly unable to function. And you're worried because your future seems uncertain now. You feel, I'm sure, that the rug's been pulled out from under you, and on top of that, you're treated like this. It's intolerable and it's wrong. And what's more, if you're getting your comp checks, hey, they're a third less than your usual paycheck, so you've had to make some serious adjustments financially in your budget as well. So more likely than not, I wouldn't be, blame you one bit if you're angry. In fact, you might be mad as hell. But at the same time, you have an eye on the future. Is there, the question's going to be, is there any way that you can pull out of this and end up comfortably back on your feet, both physically and financially? So I'm here to tell you that, first of all, in terms of feeling angry, you're not alone. You're not being personally singled out. Everybody typically gets treated poorly when they get hurt on the job. Why? It's because the whole show, since you've gotten injured, is being run not by your employer, who you might have known for many years, but by the workers' compensation insurance company and the adjuster. And the insurance company, as you may guess, is not in the business of handing out money. They're in the business of spending as little money as possible on each claim. So believe me when I tell you, even if the adjuster has been nice up until now, even if they paid for everything, no problem, there will come a time when that may very well end. So I'm also here to tell you that depending on the kind of case you have, there's a potential to come out on the other side in a very good shape financially. And that's what this CD is all about. It's about setting things up so when the time comes for the insurance company to drop the hammer on you, which may or may not happen to you, your rights will be solidly protected. So why is this so important? As we stress over and over again throughout my videos online and in my book, the employer and insurance company are not obligated to pay you one single penny or pay for any medical treatment unless they are either ordered to do so by the Industrial Commission or they officially agree to do so on the properly filed form with the Commission. And even then, there's no guarantees. So let me say that again because it's so important to remember. The employer and the insurance company are not obligated to pay you one single penny or pay for any medical treatment unless they are ordered to do so by the Industrial Commission or they agree to do so on the officially prescribed form, which is known as a Form 60. All right? Now, they may do so voluntarily for a while, and they want you to think they're amazing to convince you that you're all taken care of, but that's just to lull you to sleep. They want you to be off guard so that you're completely shocked when your benefits are eventually cut off. Now, one of the things we hear all the time is this: well, I'm pretty sure my employer filed my claim with the Industrial Commission for me. So I'm here to tell you that if you heard any such thing, it is wrong. There is no such thing. Only you or your attorney can file the document which really officially starts your claim, and that's called a Form 18. If the insurance company or the employer is claiming that they filed your claim for you, they're lying to you or they're misinformed. So what they may have filed now is a notification of injury, or Form 19. And that has nothing to do with what you have to do, and it does not protect your claim in any way. I'm going to say that again. A Form 19, not an 18 now, Form 19 is what the employer files, notification of injury, and that doesn't protect your rights in any way. So who needs to worry about all this stuff the most? Okay? Now, the ones who need to worry about this the most are the ones who I'm going to start to mention in a moment who fall into what I call a category number 2. So we're going to see that we broadly put people that are hurt on the job into 2 categories, 1 and 2. We're going to talk about that now. So category number 2, folks, are folks are covered in my North Carolina settlement book, and that's included with this CD and in the packet the toolkit that you got, and they're covered by chapters 2, 3, and 4. And these are folks who are severely injured or probably not going to be able to go back to work on their job. And in some cases, they're probably not going to be able to go back to work at all. And if that's you fall into category 2. What's this category 1 and 2? So basically, we just tend to see that workers' comp claims fall into two very broad categories, and that's what I call category 1 and 2. What's category 1? Not 2. What's the one category number 1? Now, these are folks, maybe you were hurt, but not too severely. Perhaps you suffered a sprain or a strain in your ankle, your wrist, or your shoulder, or other body part. Maybe you got some cuts, scrapes, slight burns. You might be quite young. All right, so and there's no surgery. You never had any surgery for this, or any major treatment is indicated by any of your doctors. And neither you or your doctor anticipate any significant lost time from work or future treatment. Anything, if anything, maybe you're going to have a week or two, and then you should be back to full duty, no problem. You might even have some permanency to your injury, possibly, but no future treatment is really anticipated, and it's not going to affect your ability to work in the future. In fact, you already might be back at full duty, or you're shortly expected to go back, no problem at all. Now, these folks in Category 1 are covered under Chapter 1 in my North Carolina book on settlements. So for you, although it's important to protect your rights, you're not as critical as the situation is Category 2. I'm going to explain all that in a minute. So who am I talking about Category 2? Like I said, those are folks who are severely, even catastrophically injured. And you've required, most likely, a hospital admission, not just a visit to the ER. They've admitted you to the hospital after you got hurt. Most likely, the doctor who's treating you now is the one who performed surgery on you in the hospital. You likely had surgery to one or more body parts as a result of your work injury. You may have had multiple fractures, some severe, even an amputation. You may be older, maybe approaching, age 60. And both you and your doctor are concerned that your injury might prevent you from returning to work, or at least from returning to the job you were hurt on. So for now, you must remain completely out of work due to your injuries and for the foreseeable future. So now I realize, not everybody's going to fit neatly into each category. You may not be sure if you're in 1 or 2 here, really bad off or not so bad off. You don't know yet whether you're going to be able to go back to work, for instance. So what you should do in those circumstances is just assume you're in Category 2 and proceed as we recommend for those folks. That's what you ought to do. But for those of you who know that, look, I wasn't hurt that bad, you fit into Category 1, which again is covered by my book in Chapter 1, the non-severe injury that I described. With very few exceptions, I have very good news for you. And that's this. You really don't need a lawyer, okay? Because I can basically show you how to get your claim up and running. And I've done that in this case success toolkit that you have before you, all right? So but everything you need in the case success toolkit package is there that I provided for you. So I've included in the package, for instance, some sample documents. I'm going to explain to those folks who are clearly in Category 1 basically what to do with these documents in just a second. In fact, I've included a ready reference little card, it's in the toolkit there, to walk you through the steps of filing and pursuing your claim. So let me say this, though, as a cautionary thing. Though, if you're in Category 2, you've been really busted up, really severely injured, and you're not really sure what's going to happen to your employment, or if you unfortunately have severe scarring or disfigurement or something like that, I would under no circumstances recommend that you proceed without a workers' compensation attorney. Okay? And that means an attorney knowledgeable about North Carolina workers' compensation law. Why? Because we're talking about an extended period of time with you being out of work, or the potential for substantial sums of money to be paid to you in settlement. It's absolutely essential that we take steps to protect your benefits and protect them right now. If not, you can lose them at any time. How? So this connects back to the principle that we talked about just a moment ago, and that is, again, the employer insurance company are not obligated to pay you one single penny or pay you any medical treatment for any medical treatment that you have unless they're ordered to do so by the commission or they formally agree to pay you with a Form 60. So what would you do if a year from now, still unable to work, your benefits are cut off? What if they were cut off tomorrow? How are you going to support yourself and your family? So in addition, those of you in Category 2, you may have also suffered from multiple injuries. And it's important that an attorney with expertise looks over your records, your medical records, make sure that everything is filed appropriately and included in any forms that were filed with the Industrial Commission. Just because the carrier, understand, agrees to a small portion of your injury does not mean they've agreed to all of it. So this could prove very crucial at a later time. Also, if you're in Category 2, your medical records are going to be extensive and they're going to be huge. You can rely on the expertise of a knowledgeable workers' compensation attorney to sift through those records and make sure that your doctors are also protecting you. Because here's a big surprise. Doctors and nurses don't always write down what you tell them. In today's digital age, they often rely on automatically filled in reports. So what if your doctor has not properly noted the fact that you were hurt on the work, that you were hurt on the job, or the record said that you didn't suffer from any trauma that is from an old, or the trauma that's from an old injury or something that they found. And I've seen this many times. And if that's the case, it needs to be corrected as soon as possible. When you think you told the doctor one thing and it's not in there. In addition, if you're suffering from some severe incapacities due to pain medication, and weakness, you can rest assured that the insurance company is going to be taking full advantage of you by sweet-talking your doctors and taking steps to diminish the value of your claim. Believe it or not. So you might ask, well, how can they do that? What about patient privilege and all this stuff? The answer is because when you have a workers' comp claim, you essentially have no doctor-patient privilege anymore when it comes to the workers' comp insurance company and their minions. And I warn about this extensively on my website and videos outlining the dangers of dealing with what I call the defense professionals. And it's what I call sort of the unholy trinity of defense professionals. That's the insurance adjuster, number one, the nurse case manager is number two, and the vocational rehab expert, that's number three. And with very few exceptions, all of these folks are aligned to accomplish one goal, and one goal only: to destroy your workers' compensation case, or at the very least, minimize its value. But for now, let's go back. I promised the folks in the first category that I'd help them get started on their claim without hiring a lawyer, so here goes. I'd also say that a lot of my comments and instructions along the way do apply to Category 2 folks also, so just don't gloss over this no matter what category you're in here. So the documents I've enclosed for the less severely injured Category 1 folks to file themselves are as follows. And by the way, all those documents can be downloaded on the North Carolina Industrial Commission website. But I've included hard copies of them in your toolkit. So document number 1, you see there is a Form 18. That gets your claim started, and you got to file it within 2 years of the accident. And we're going to go back over these one by one. Okay, and document number 2, that's a Form 60, which we talked about a minute ago. That's the acceptance of your claim by the insurance company employer, a potential response to the Form 18 that you filed. Document number 3 is a Form 61. That's a denial of your comp claim. Document number 4 is a Form 63, which is payment without prejudice form that is filed by the insurance company or the employer. Document number 5 is a Form 33, which is a request for hearing. You should only file this in the event you get a Form 61, which is a denial. Okay, and so let's real quickly go through these steps for successful case outcome. Again, these are tracked on that small card that I've included with your toolkit. So let's go to step number 1. So Category 1 folks, and also Category 2 folks, this is crucial. If you've recently been hurt at work, step 1 is that you've not already done so. Please make sure you've given appropriate notice, preferably written, to your employer of your injury on the job. You technically have only 30 days from the date of accident to do this, and is ideally should be done in writing. And most employees, that I've seen, this is done with an accident report that they, official accident report that they have that you fill out. But if your employer doesn't have that, don't assume they know about your accident. If you did not notify a supervisor or someone in authority, they may claim that they had no notice of your injury. So don't rely on the bosses that tell you, well, we don't want to report this. We've seen many times that this backfire on folks that get hurt on the job, and they ask you not to report it, and then they claim it never happened. Please don't fall into that trap. Report your injury. So that's step number 1. Step number 2, you should obtain medical records from your treating doctors for your work injuries. Okay? This is not just the stuff they give you when you leave the office. These are the actual office notes that are dictated by your treating doctor. You need to request that your doctor provide those to you. Most importantly, if you're being held out of work or you're on work restrictions, you got to get any out of work notes or work restriction notes holding you out of work or putting you on modified light duty from the doctor because of your injuries. That is crucial every time you go. Step number 3. After you've done all that, gotten those records, step number 3 is to go ahead and fill out document number 1. Document number 1 is the Form 18 that I've included as per the instructions on the website, on the NCIC website. Now, they require that you electronically file that document with the Industrial Commission nowadays. You want to put the correct date and the time and the city and the county of the injury. You want to put the specific body parts that you're claiming that were hurt. You want to describe how the accident happened. Put your occupation when you were hurt and how much time you missed and your average weekly wage. Now, your average weekly wage, what's that? That is the gross amount that you are paid every week on average from your employer. So that's your before tax earnings, not your after tax, your before tax earnings. And there's also additional instructions on the back of your Form 18 to figure all that stuff up. Okay? So that's step number 3. Step number 4, you want to file that document, that Form 18 with the Industrial Commission electronically. Make sure you retain copies of everything. Okay? Don't file anything that you don't keep a copy of. Now, please know this, and this goes for everybody, Category 1 and 2. You have only 2 years, up to 2 years from the date of the accident to file this document. That's the Form 18. After that, it's over. You have no case. Okay? That's the deadline. If you miss it, you're done. So make sure you file it within 2 years of the accident. Now, there may be some exceptions if you've been paid workers' comp checks on, all along. And if you're not sure if you're beyond the deadline at this point, please call our office. We'll be happy to help you figure that out. Okay? Now, sometime after filing your Form 18, you should get either a Form 60, 61, or 63 from the Commission. Those are documents number 2, 3, and 4 that I've included in your toolkit there. So if you get a Form 60, then congratulations. This means your case has been accepted by the insurance company. That's great news. Now, if you get a Form 61, that means the insurance company has denied your claim. Now, pay careful attention, and they're going to put in there the reasons they set forth for denying your claim. Form 63 is kind of in between, number 60 and 61. Even though it comes after, it's really kind of in between. What they're basically saying is, we're going to pay you, either your checks and or your medical bills for up to 90 days. But in the meantime, this is the insurance company saying they're still investigating your case, meaning we reserve the right to still deny your claim if we find something we don't like. Okay? But after 90 days, they're supposed to file either a Form 60 or 61, and they're either supposed to accept it or deny it after 90 days. They can't just keep doing that in perpetuity. They can't continue to deny, to leave you, where they're not saying, they're not committing one way or another whether they're going to accept the claim or not. Okay, so that's what the forms are included. Now, step number 5. Hopefully, you'll not have to, but if your claim is denied, you may have no choice, and that's to file a Form 33. That is a request for your case to go to a hearing with a deputy commissioner. Document number 5 is a sample of what the Form 33 looks like. And if you're headed to a hearing, you might want to speak to a workers' comp attorney, because lots goes into preparing for a hearing, and that's a little beyond the scope of this CD presentation. Okay? So, Category 1, folks, that is basically what you need to do in order to get your benefits going and determine what the insurance company's stance is on your claim. Now, I want to go back to Category 2, folks, the most severely injured folks, for a couple of minutes. Now, Category 2, folks, those of you who are hurt severely. Again, I really invite you to read my book, The North Carolina Workers' Compensation Guide to Settlements, and pay particular attention to the introduction and chapters 2 through 4. I'm talking to those of you who don't know if you're going to be able to go back to work. Those of you who are laid up and had surgery or expecting to have surgery, that's what I'm talking to. Because if you've been listening to everything that I said to Category 1, folks, one thing should have been crystal clear to you. You are in no condition to do any of these things at this point. And what's more, you have way too much to lose. If you're hurting, you're laid up, you're disabled, you need a team of folks that you can count on to take care of getting your medical records, communicating with the Industrial Commission, communicating with the adjuster and the insurance company, filling out all the appropriate forms with the Commission in a way that will protect your rights for the foreseeable future, and find out for sure what the insurance company intends to do on your case. You want a team to handle all that for you so you can do what your only job is at this point, which is to heal and get better. That's all you have to do. So those of you who fall into Category 2, you really should not, under any circumstances, attempt to do all this on your own. I invite you to call us, please, and see if we can make you part of the family at the Work Injury Center, because this is what we do. We educate, we inform, and we practice strong justice for the clients we accept into our family. What we do, our main mission, is we help people whose lives have been disrupted by serious injury to restart and rebuild their future. That's what we do every day. I'd ask that you please consider it. See, your income, your career, your livelihood, I think it's just too important not to do this. Now, on my website, one of the videos that you can see on there, on the Work Injury Center homepage, tells a story about this guy, this gentleman, who called our office, and he had a terrible injury. One of his hands was chopped off by a tagged out factory machine. He was working in a factory, and the machine was tagged out. Tag had been accidentally removed, and he worked the machine. It was defective, and he got hurt. He lost his hand. Now, unfortunately, the injury had occurred many years prior to his call with us. What prompted his call? Why was he calling now? Well, he returned to work at his employer with his one hand missing. Employer took him back. Said, "Come on, we got a job you can do with one hand." And now he'd been fired by the employer over 10 years after his injury. And, we so look forward to helping this man. We really did. But it turns out he never filed a single paper to protect his rights. And his rights had long since expired. There wasn't a settlement for future medicals. There was no recovery for what he would have been 100% permanent impairment on his missing hand, for his rating on that. No way to get him any additional ongoing benefits, even though he was likely under long-standing light duty restrictions from his doctor. Probably, and all the prosthetics he would have needed on his hand, all the payment for that, gone. We were completely hogtied and powerless to help this man. So let me tell you, that was an awful feeling. And it does happen from time to time. We get these calls like this. That he's not the only person that we dealt with in that situation. It's an awful feeling of being so powerless. We felt so bad for this man because he could have been in a much better position in his life, financially, medically, everything. How is he going to afford replacements for the hand prosthesis? How could the employer have just let his rights expire without letting me know? How could that happen? And that's the point of this story. No one, not your employer, the insurance company, anyone is going to take care of you no matter what they tell you, okay, that's working for those folks. It is not in their interest to help you. If it's up to them, the best thing would be for you to remain ignorant of your rights and take no action, just like this poor gentleman in the example I gave. We urge you not to let happen to you what happened to this man. Now, you might be thinking, I'd love to hire a lawyer. I can't afford one. So I have some great news for you. To hire myself and my team, you don't have to shell out a dime. Our fees are almost entirely come out of any settlement we may eventually obtain for you. Now, I will say that sometimes, if we end up having to get a hearing or make an important motion that we have to do on your behalf, the commission may award us every fourth check of ongoing compensation as an attorney's fee. But way more often than not, that doesn't happen at all. We typically only get paid out of your settlement, and typically the Industrial Commission is going to approve a 25% of your settlement as our fee. In the meantime, you don't pay anything. Now, excuse me, our goal for you, which we also benefit from the most, as is described in the little green book that I've written, which you have a hard copy of, the North Carolina Workers' Compensation Guide to Settlements, our main goal is to get your case in a posture that offers you the best possible chance of obtaining a significant settlement, and by that I mean at least 6 figures, so that you can move on with the rest of your life and not worry about being financially strapped. And while every case is different, and no lawyer can ethically say that they can guarantee you anything, I invite you to look online at theworkinjurycenter.com for our string of successes over the years. You're going to see that what we've done it again and again for our clients. We continue to keep doing it day in, day out. So, before I close this CD, I want to mention one more thing. So in actuality, there is actually maybe a third category of folks, really a subcategory of 2B, if you will. And that category is made up of these folks, or those folks who are severely injured and out of work, and maybe listen to this CD and think, well, that doesn't apply to me. This doesn't apply to me because I've already done all that stuff he's talking about. I'm talking about those of you, for whatever reason, you've already filled out your Form 18 and you've already received a 460 from the employer, which means you got an accepted claim. You're receiving your weekly temporary total disability checks, your workers' comp checks, and all your extensive medical treatment is being covered by the workers' comp carrier. And to that, I say to you, congratulations. Either you worked hard to figure out how to protect your rights by studying up. Maybe you or your very smart spouse studied my website, the Industrial Commission site, or other lawyers' websites, or you just lucked into the rare insurance adjuster who was willing to help you out. It occasionally does happen. So you have an accepted claim, and therefore you're home free, right? Answer is a big, gigantic no. No way, you are not home free by any stretch of the imagination. And again, I'd refer you to our website where I discuss the numerous traps whereby the workers' comp insurance company can still take away your benefits, even if you're under an accepted claim. Now, in North Carolina, all they have to do is file something called what's called a Form 24, which is like an atomic bomb. Why? Because that's a motion to cut you off your benefits. And you only have 14 days to respond to a Form 24. And from that day forward, if you fail to appropriately respond, your benefits will be cut off. Now, how do you keep that from happening? Well, to be truthful, there are some circumstances where you can't. For instance, if your doctor releases you to full duty with no physical restrictions, you're going to lose your ongoing weekly check. Although your medical benefits are going to remain intact. And if you're released to light duty, and your employer decides to accommodate you by offering you a light-duty job at the same pay rate that you were on when you got hurt, that's also going to stop your weekly benefits. Although, again, your medical benefits are going to stay intact. But in those circumstances, the employer is probably going to file other forms like a 28T indicating a return to work. But besides that, there are additional ways you can lose your benefits. And there are ways you can keep that from happening. These things are usually accomplished through the schemes of what I've referred to before as the unholy trinity of the adjuster, the nurse case manager, or the voc rehab counselor, or sometimes because you just made a misstep. How do you prevent these missteps? Again, there's no guarantees, but the best way is to have a good lawyer with a team of folks who know the system to advise you how to make sure you don't engage in behaviors that will get you kicked out of your benefits. Because the fact of the matter is that by just being a little absent-minded or just being a little hard-nosed and saying, no, that's stupid, I ain't going to do that, you can lose your benefits in 1 second. And it can be almost impossible to ever get those benefits back. And remember, that's despite the fact that you might be under an accepted claim. So to learn more about that, I'm going to refer you to our website, theworkinjurycenter.com. Take a look at our video on the defense professionals. Also have a look at our YouTube channel for additional videos about nurse case managers, private investigators, as well as all our blogs on our website, the Work Injury Center, for a better idea of what you're up against, because we get into this quite a bit. Now, I want to thank you all very much for taking the time to listen to this CD. I hope you've learned a lot. And now you have some idea of what you need to do to ensure your rights are protected. In the meantime, if you've been severely injured on the job and you have questions about your case, please call us and don't wait. If we decide to accept your case, as I mentioned above, you become part of our family. That's the way we look at it. As you may have read about in the book, we practice something at the Work Injury Center that we call strong justice. It means we focus on helping those who we feel we're in the best position to help. We don't take every case that walks through the door. All right, that's what we do here. We believe that's the best way to serve our clients. If I'm your lawyer, you need to know that anytime there's a need for you to talk to me, my staff's going to schedule a telephone conference as between you and myself. I have special time carved out to speak to my family of clients each week for that very purpose. All right. So I know this is a big decision for you, so please think about it. Remember this: if you're coming up on a time frame when you may be released by your doctor to light duty, you don't know if you have an accepted claim, your benefits might be in big trouble. So don't wait. Okay, call us right now. In the meantime, if there's anything we can do for you here at the Work Injury Center, or if you have any additional questions about your claim, I invite you to contact us at 1-888-310-7798. That's Joe Miller Law, 888-310-7798. One of my assistants will be happy to set up a time for you and I to speak about your case. Okay? And I also invite you, again, to explore the wealth of additional information you're going to find at www.theworkinjurycenter.com. Now, this is Joe Miller, attorney. I want to thank you all so much for listening. God bless you and your family.